Good morning, everybody. My name's Kyle Wiley. As mentioned before, I'm a co-founder of Connector Labs, previously served at the U.S. Department of Energy as senior advisor. Very excited to have a conversation with my other co-founder and also founding partner of Carstens Gourley, David Carstens. David, I'll let you give an introduction of yourself.
Thanks, Kyle. I appreciate it. Also, it's been so wonderful being here in Miami for the World Strategic Forum. This is my first time here, and I've just am so impressed by the quality of this conference and the people we've been meeting. My name is David Carstens, intellectual property attorney. Background in a couple of different engineering disciplines, law degree. In addition, for a long time now, over almost 30 years, I've been teaching as an adjunct professor, teaching international intellectual property law. Really fascinated by the growth of intellectual property around the world, the changing dynamics, and how it affects trade. And so we thought this would be a good opportunity to discuss some of those topics.
Sure. David, I'll let you kind of kick it off and lead the discussion.
Sure. Well, over the years, one of the things we've seen is that almost all companies have three things in common. And that's true even in this new economy, which is they've got to have access to funds. They've got to have an ability to innovate so that they can stay ahead of their competitors. And also, they've got to have good customers. And what we've realized is the United States government is kind of an answer to all three of those issues. The United States government is one of the major funding sources now for innovation. It is a fabulous resource in terms of being able to cooperate with government labs and other government agencies to improve your competitive position. And then finally, of course, they're probably the largest customer in the world. So, with that said, I was going to ask you a few questions about the most important topic, which is money. Not to be too crass about it, but it's I can't help but notice the sheer number of funding opportunities coming out of the government, the U.S. government, that amount to what seems like hundreds of billions, if not maybe even $1 trillion of money being spent to shape the new economy.
Yeah, I would totally agree with you there, David. We're seeing a lot of funding coming, nearly $1 trillion out of the U.S. Department of Energy, where I served as senior advisor. We specifically were looking to commercialize technology from the 17 national labs. So in addition to the nearly $1 trillion that you're seeing coming out of the Department of Energy, they also spend about $40 billion a year on research and development just for their national lab complex. And I think you're also seeing a lot of funding coming out of the government targeted at defense purposes, things like critical minerals, semiconductors, really looking to try and onshore a lot of that technology that we have previously offshored and bring it back into the fold of the United States. And that kind of leads me to another question, David. Talk to me a little bit about the benefits and drawbacks of harmonizing international IP and how that factors in with the government.
Sure, because, harmonization has been kind of the buzzword around international intellectual property for the last 30 years. Prior to 1990, roughly, the world was kind of a patchwork of different systems. And, with the advent of the World Trade Organization, and there was an additional treaty called TRIPS, and some of you may have heard of TRIPS, trade-related aspects of intellectual property. That was the main driver toward harmonization. And so, the goal was that if you were a company and you were wanting to expand, to another country, and maybe you're a foreign country and you're coming into America, you understood what the rules were going to be. The patent rules in the U.S. now generally match the patent rules in Europe. The trademark rules, in the U.S. match the trademark rules in South America. And you could anticipate what the needs would be and what the requirements were, and more importantly, that there would be meaningful enforcement of your rights overseas. And TRIPS was really the first treaty that mandated minimum enforcement standards around the world. Now, it's never perfect, and in fact, some countries have different enforcement mechanisms that maybe match up and maybe they don't. But at least there's a mechanism now to resolve those disputes more peaceably.
Absolutely. And resolving those disputes typically happens through the government. What kind of role does the government play in protecting IP, intellectual property?
Boy, it plays several roles. First of all, we have a very robust patent office here in the United States. 8 to 10,000 examiners on staff to review patent applications. Hundreds of thousands of applications filed every year. The majority of them now coming from Chinese companies, I'll mention.
Surprisingly.
Yeah. But that said, on the administrative side, the patent office is a very well-run organization. We also have a very robust federal court system for enforcement. And then also, there's kind of an overlooked part, which is the U.S. Trade Representative. They have these Section 301 actions where they can impose tariffs on foreign nations based upon unfair trade practices, which sometimes involves failure to enforce intellectual property properly.
Absolutely. I think saw a lot of enforcement mechanisms when I served at the Department of Energy, instances where we literally had foreign nationals making copies of papers. And that was something that we really focused in at the department, and making sure that there was no taxpayer funded projects going to certain nefarious actors across the world. Talking more internationally, David, with IP rights, how does that affect trade relations and foster innovation?
Yeah, intellectual property rights and trade really go hand in hand. In the best of all worlds, when you're dealing with commodity goods and you have trade, it's very easy to enforce trade norms. In other words, if one country is more efficient at producing farm, products, and another's more efficient at producing, refined minerals, it's easy to trade those sorts of commodity products. When one country, though, has a competitive advantage in intellectual property, it's much harder to enforce trade, because you can send a single copy of, Windows to a country and they can make 10,000 copies of it on their own. And so you have to have a more robust set of trade regulations, and that sometimes involves bilateral trade agreements. And almost all the good bilateral trade agreements now include a substantial amount of intellectual property language to try to ensure that one country's IP is respected in another country.
Sure. And on the trade agreements, I know focused a bit on energy earlier. Is IP helping or hindering the transition to green energy and renewables that you're particularly seeing from the U.S. and the U.S. government rolling out a substantial amount of funding?
Yeah. Well, intellectual property, I think, is essential for providing incentive to the development of any new technology. And so green energy is really no exception. When you're dealing with green energy, a company that spends a lot of money on research and development has got to have some ability to recoup that cost. And the problem with any brand new idea is, of course, it costs more to generate it than it does to copy it. And so you have this problem of a free rider, somebody who chooses to simply not spend the money on research and development, but simply copy somebody else. And so if you allow that to go unfettered, the problem, of course, is the first company will go out of business, and so they'll stop innovating. And so you've got to have some ability to exclude others from making or using the innovative technology, especially around green energy.
Yeah, absolutely. I know Department of Energy, Department of Defense, even things like the Defense Production Act are being utilized to onshore green energy, critical mineral projects, lithium extraction, cobalt, a lot of the things that we've touched on earlier, that the U.S. is particularly focusing a lot on, bringing that back into the fold.
I'd like to ask another question of you, which is, it seems like when you're dealing with the government, there's so much money involved, and there's so many different avenues to approach them. If you were a small startup that needed some assistance, how can that be done? In other words, I'm impressed by the national labs, especially National Renewable Energy Lab up in Colorado. A fabulous facility, great scientists, cutting edge work. But if I was a small company, how in the world would I even engage with them?
Yeah, that's a great question. That's one of the things we'd really tried when I served at the department to bring more people into the fold. Department of Energy, DoD, might seem like very scary, large entities, but they really do want to partner and work with you. It can be something as small as a cooperative research and development agreement that's, you just need a couple $100,000 to commercialize technology. And you can do that with a National Renewable Energy Lab. On the DoD side, they have tech scouts that are literally scouring the country looking for innovative technology. The folks over at DARPA, we were talking to DARPA the other day about a project where we're using sound waves to map interior environments. And they're also trying to use sound waves to put out fires. So very high level kind of wild ideas, back of the napkin types. So I think, the government wants to partner with you. I think you're seeing that in the Biden administration. They're not too friendly towards certain industries like oil and gas, but obviously they're trying to move things over to the renewable side.
Well, you actually took the question out of my mouth almost, which is, it seems like there are some preferred industries right now. Whether you agree with that or not, tell me a little bit more about which industries seem to be garnering the most funding.
Sure. I think when you look at the onshoring that we want to occur in the U.S., especially making sure that we're protected here, both intellectually with IP, but also strategically. So being able to produce microchips in the United States, being able to produce the pre-product wafer that goes into that microchip. And you can use things like the Defense Production Act with the federal government that is bringing in critical minerals or mineral extraction, microchips, all the components of this green energy technology. The U.S. government is placing a top priority on onshoring that technology.
Yeah, it's not just necessarily through funding mechanisms. I've noticed that there's a lot of tax incentives out there too. We have some clients that are in the renewable energy space that are looking at something called 45Qs, which I only kind of understand, but it seems like it's pervasive, the push right now to try to motivate America into kind of a new direction in this new economy.
Yeah, I think it's a carrot and stick issue. If you look on the EPA side, the enforcement side, that's definitely a stick. But then on the DOE side, that's much more of a carrot with the funding that they're announcing, the ability for Treasury to lay out tax incentives, like you mentioned, through the IRA and the bill that was passed earlier this year. 45X is another, tax incentive that's not always talked about. So I think tax incentives can be a key part, but if you're a small startup or mid cap, you're really looking just to get some dollars in the door and start forming those partnerships at the national laboratories and working with the scientists. And we really tried to focus at the Department of Energy on engaging industry into the national labs. The scientists will talk zeros and ones all day long, but at some point we have to say, can we get a return on this taxpayer funded research and development? So that was a big priority for us during our time at the Department of Energy.
As I've learned more about the national labs over the last few years, they're absolute gems. And right now, I think you said there are 17 national labs, with each one having its own general focus and maybe some overlap in some focuses, especially around energy.
Sure. Yeah. They focus on everything. I'm sure a lot of folks here saw Oppenheimer this past summer. That technology was developed at Oak Ridge National Laboratory in Tennessee. So the scene where they have the wall that takes in all the rods, I've seen that. It's called Y12 Combinator. There are DOE labs that focus specifically on national security and nuclear. They keep the aliens out in New Mexico. If you ever want to go check those out. But yeah, it kind of runs the gambit, and DOE works on issues that you wouldn't consider. So DOE owns and maintains the most powerful supercomputer in the world. It's up at Argonne National Laboratory in Chicago. So you hit the point on the head where you say they are literally the national gems, and very excited to work with you. How does it come in with the IP side and working with the government, David?
That's a great question, because there's really two aspects. There's already a substantial amount of intellectual property owned by the government that is available for licensing. And so if you find that your own technology staff may not quite have solved a problem yet, certainly look at the labs and see if maybe they have solved it, and maybe that solution is available for licensing. The second way is really through these things called cooperative research and development agreements, CRADAs, C-R-A-D-A. And CRADAs are a great way for organizations to partner with not just the lab, but really the scientists at the lab, and also to be able to use the facilities at the lab. We had a client last year that is trying to create a new kind of a technology around energy production. I can't go into too much detail, but the equipment to test it is extraordinarily expensive. But of course, they have one at NREL, and it's just a matter of now working with them to get time to use that equipment. And so it's a great way of supplementing your own technical staff.
Absolutely. Just kind of winding down here a little bit. The theme of the IEFA World Strategic Forum is mastering the new economy. How does that play with IP, in your opinion?
Well, I think IP is going to be absolutely essential to the new economy. In the 1950s, it was about inventory and machines, and the company's wealth was based upon its assets, its hard assets, its physical, real property and personal property. I think that trend has been changing for the last 20 years. And I think if you'll see a lot of studies, they'll say that, 70% of the value for most technology companies is really their intellectual property. That ability to create a moat around their business, so that it's not easy for somebody else to compete with them. It is an increasingly competitive marketplace with increasingly sophisticated competitors, and not only competitors in the U.S., but competitors from around the world. Like I said, I've been teaching 20 plus years now on international IP law, and we spend more and more and more time talking about the intellectual properties challenge coming out of China, which is substantial and cannot be underestimated. They have gone really from a country with a terrible reputation as being an infringer, a copier, to being much more of an innovative economy. They've kind of moved themselves up the learning curve, and that should worry everybody, because I think they're going to start. Like I said, they're filing more patent applications in the U.S. now than U.S. companies.
How does it look filing application for a U.S. company in China?
That's a great question. There's of course, this TRIPS treaty that we've talked about earlier that requires something called national treatment. National treatment is something you'll find in almost all of these treaties, which basically says a U.S. applicant in China has to be treated the same way as a Chinese applicant in China. You can't discriminate based upon country of origin. And yet, for a long time, it's one thing to get the patent or the trademark. It's another thing to be able to actively enforce it. Without the enforcement mechanism, a lot of times it really hollows out the value of your foreign intellectual property assets. But having spoken with many Chinese judges now and other administrative officials, they can certainly point to a lot of statistics showing that foreign plaintiffs in Chinese courts do as well as Chinese plaintiffs in Chinese courts. But of course, one of the other things you see is that the amount of damages then awarded are trivial. And so there's an economic disincentive.
Pennies on the dollar, or?
Yeah, pennies on the dollar from what it probably should have been. And that's just because of the nuance of Chinese damages law. But that said, there's even that's a little bit of a disincentive then to enforcement in China. You can spend $1 million and win 10,000. And that's a lot of people just don't want to do that. So,
yeah, absolutely. Well, David, as we kind of close it out here, what do you see in the future for IP?
Oh gosh, increased emphasis on it. Smart companies are recognizing that it's important to act with speed. One of the things that happened during harmonization of U.S. patent law was we stopped being a first to invent country and we went to what's called a first to file country. For 200 years, the guy who first came up with an idea was the one who got the patent. And that changed now to the first one to get the application on file at the patent office. And so speed, surface ideas quickly, move them forward quickly or archive them quickly, but speed is the key.
Excellent. Well, thank you so much, David, and wonderful conversation.
Thank you very much, Kyle. Appreciate it.